Thank you, John, and congratulations to you for reaching the finals. That's a significant accomplishment that you should all be very proud of. We'll introduce ourselves, as John said. My name is David Hudson. I teach at Belmont University College of Law in Nashville, Tennessee.
I'm Hank Chambers. I'm a law professor at the University of Richmond. It's good to see you all this afternoon.
And I'm Ben Glickman. I'm an attorney with the California Attorney General's Office and also an alumnus of this program. I was on a nationals team way back in 1995. So congratulations again on making it to the top 12.
Good afternoon. We are Foothill High School's Unit 5, representing the state of California. My name is Barrett Fahey.
My name is Justin Choi.
My name is Rohan Abraham.
My name is Mary Thurlow, and we'd like to thank the judges, the audience, and timekeeper for being here today. And we'd like to introduce our coaches, Mr. McBride, Mr. Dedamore, and Mr. Telfs.
Excellent. We have chosen question 1 in Unit 5 for you, which I will read. A result of the decision in Wisconsin v. Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights?
In Wisconsin v. Yoder, 1971, the court found that the Amish were justified in limiting their children's education, as it was unnecessary to their religious life, especially for an endangered religion. The case has been controversial in its reception, and our unit reflects this split. Justin and I feel that this decision correctly interprets education as a positive right that people may refuse if they believe it to be non-beneficial or a violation of their negative rights.
However, Mary and I disagree with this decision and agree with Justice Douglas's dissent that the majority opinion prioritizes the rights of the parent over the rights of the child, when the education of the child is a matter on which the child will often have decided views. In truth, the Free Exercise Clause guarantees that the government may not infringe on an individual's practice of their beliefs. It does not state that individuals may force their beliefs onto another person, even their child.
Rohan and I, on the other hand, agree with the court as it decided Yoder as a compromise between religion and the state, with the understanding that both the parents and the students themselves value their formal education less than their religious beliefs. Should a child want to break from family tradition, the law and the courts give them ample opportunity to do so after they turn 18. The Constitution guarantees that the government may not infringe on people's religious practices, and it does not explicitly guarantee a right to education for minors.
Although Yoder determined that there are no direct mentions of the right to education in the U.S. Constitution, this is partly due to the fact there was no such thing as public education during its writing. Instead, education was conducted primarily through the church. Scholar Charles Fahey noted that, by this logic, the First Amendment protected the people's right to education, at least a religious one. As more states adopted secular public education requirements, education lost its protection through the First Amendment.
The Supreme Court further denied any federal right to education in San Antonio Independent School District v. Rodriguez, 1973, viewing it as a purely state-level right. Every state constitution has a reference to a right to an equal and fair education, but the qualities of these educations differ, especially within lower-income school districts, demonstrating that a right to education is not enough. Instead, it must be coupled with corresponding legislation to ensure its protection.
Our home state of California reflects this necessary balance. Article 9, Section 1 of the California Constitution identifies a responsibility for a statewide education system open to all. With the power of the Education Code behind it, a series of bills updated each legislative session, the right to education in California acts as more than just a symbol, but rather as an essential protection for all Californians by creating funding and set standards for diverse courses.
When religion comes into conflict with statutory rights, such as access to contraceptives or civil rights laws, the question arises which will take precedence. Recent courts have sided with religion over other rights, using a combination of the Free Exercise Clause and an aggressive interpretation of the Religious Freedom Restoration Act, which has allowed religion to develop into a tool for depriving citizens of other crucial rights.
Although Justice Scalia's majority opinion in Employment Division v. Smith, 1990, states that religion cannot excuse an individual from an otherwise generally applicable law, this standard is now hanging by a thread. Scholar Lee Epstein noted that the Roberts Court decided for religion in 82% of cases and only 18% against, a huge shift from previous courts. Recently, the court wrote in Tandon v. Newsom, 2021, that government regulations trigger strict scrutiny whenever they treat any comparable secular activity more favorably than religious exercise, a step back from Smith and towards religious rights.
In a 2020 article, scholar Howard Gilman wrote of the weaponization of the Free Exercise Clause, noting that many groups use this clause as a tool to discriminate against the rights of other individuals. The court must protect the principles of the Free Exercise Clause in the practice of an individual's religion, but not at the expense of other essential rights. Thank you.
Thank you very much. We'll begin the follow-up Q&A section now. In light of what you said about the Roberts Court and Employment Division versus Smith, wanted to get your thoughts on whether you think Employment Division versus Smith was correctly decided or not. I
do agree that the Employment Division v. Smith standard, it was a correct one. And I believe that because I think that it balances the rights of religious groups and non-religious people more equally. And also I think that the Religious Freedom Restoration Act really puts an axe to the Smith standard in that it usually makes religion trump over any secular activities.
However, one flaw of the standard established in Employment Division v. Smith, as Justice Blackmun dissented, is that it disproportionately affected the Native American religion at hand. While Christian religions generally do not suffer that same fate, peyote, an illegal drug, is essential to that Native American religion. Whereas during Prohibition, Christian religions were granted an exception for wine in their religious practices. So they were granted exceptions within the law, whereas Native American religions had the law written against them.
So let's pick up that thread. So you mentioned in your opening remarks that the recent decision in Tandon kind of has Smith hanging by a thread. Do you think Tandon was correctly decided, and can it be reconciled with Smith?
I believe that Tandon was correctly decided and that it can be reconciled with Smith. Justice Kavanaugh's majority opinion hinged on the fact that coronavirus does not care whether you are a priest or a pagan, atheist, or a Jew. It will infect anyone who it violates restrictions that are designed to protect people from it. And these restrictions placed a burden on religious organizations that was not placed on certain secular activities. And I believe that the Supreme Court correctly interpreted these statutes to be placing an undue burden on religion and therefore compromising the state's stated interest in public health that they used to try and justify these restrictions under the precedent of Jacobson v. Massachusetts, which allowed for public health laws that abridge certain rights.
However, go ahead.
I disagree with my unit mate, and I think that the standards set in Jacobson v. Massachusetts 1917 should be taken more into consideration with this case because it concerns the health and safety of other individuals. And I don't think that when California made this law, they were making it to antagonize religion or prohibit religion. I think that they were taking more into consideration what occurs inside of a church, and that usually consists of people in a closed setting, often singing, which is not advisable due to COVID-19 regulations.
So is it fair to say that Smith protected only against intentional discrimination?
No, I don't believe that when Employment Division v. Smith was decided that it would be more towards a discriminative toward discriminating against certain religions. I believe that it was just more set towards providing that balance that between secular activities and religion itself, that if the government were to be involved and if government laws and regulations were to be involved, that the government regulations would trump the person's religious rights in general.
I would say that one case that relates to the discrimination of a religion would be the one concerning the Church of Babalu Ai, where the Santeria religion of Florida had a law that was blatantly discriminating against it, where that religion involved sacrificing animals. And Florida had placed a law, the city at hand, had placed a law against that practice, despite the fact that it only affected that religious group. And the Supreme Court recognized that and noted that this law completely violated the free exercise clause.
And to go off of what my unit mate was saying, and I think this comes back to the point that Justice Scalia wrote in his majority opinion in Smith, is that religions should not be excused from a generally applicable law. And that law that that was made in Florida was not generally applicable and targeted towards that specific religion.
Should there be a right to education under the federal Constitution?
I believe there should be. As we can see in many states, they do have writing of a right to education in their state constitutions. However, as we've seen in many states, such as Michigan, there have been many disparities and students are not able to receive equal education to other people around, other kids around the nation. So we have seen in cases like Gary v. Whitmer, 2015, the district court or the circuit courts have cited that there should be a right to education at the federal level. However, it is still in dispute with San Antonio v. Rodriguez.
Would the federal government need to take over education if there were a right to an education in the federal Constitution?
Well, the federal government already plays a very important role in education and does to a certain degree use fiscal federalism in order to influence the standards that states set for education. We've seen this at play multiple times, such as during the Bush presidency with the No Child Left Behind initiative. And I believe that this would simply be an expansion of that role regarding fiscal federalism for public schools, because the issue at hand in San Antonio v. Rodriguez was funding inequality between schools. And I believe that it should be the job of the federal government to ensure that schools receive equal funding if there were to be a right to education in the Constitution for the federal government.
I'd like to piggyback off my unit mate's point. I think one essential idea that if the government were to adopt a federal education standard is that, as we can see in our home state of California, the wording of the right to education allows room for our citizens to challenge it if it does not adequately meet their needs, if it is not applied equally. And so, as we've seen in cases where the ACLU challenged the state in Williams v. California, 2012, an adequate right to education is one that not only ensures the government will provide it, as it is a positive right that they are guaranteed to provide, but that the citizens have room to speak if they feel it is not being adequately met.
So let's go back to Wisconsin v. Yoder. If Mr. Yoder had disagreed with his parents and wanted to exercise a right to education to continue in school against his parents' religious wishes, how would the court, or how should the court decide that question?
I think that is primarily where my concern came in with the decision of Wisconsin v. Yoder, is that it completely disregards the opinion of the child and places the religious opinions of the parent over that child. And I would say that at an 8th grade age, which is what Wisconsin v. Yoder was concerning with, or the age of the kids that it concerned, I believe that a kid at that age is certainly mature enough to decide whether or not they would like to continue their education at a high school level.
I disagree with my unit mate on this issue, and I believe that Wisconsin v. Yoder correctly interpreted the Amish situation, and even in a situation where a child would disagree with their parents on this issue, I believe that the court has largely stuck with the ability of the parent to control a child's destiny in cases such as Troxel v. Granville 2000, which gave parents broad control over the lives of their child.
Would your answer change if there was a declared fundamental right to education? In other words, you'd have two fundamental rights go into battle. Would your answer change in that case?
In my personal opinion, I believe that the right to education would be a positive right, that people should have the ability to disregard or not take part in if they do not wish to have it or they consider it a violation of their negative rights. So a federal right to education, I believe, would still leave room for parents to take their child out of school for religious reasons.
I'd have
However,
to, oh,
go ahead.
I would have to disagree with that. If there was to be a federal right to education, and if to go back to my unit mate's discussion, that if you view education as a positive right, if the kid is wanting to receive that sort of education past the grade 8 of school in middle school, the child would have, I believe, the ability to restrict the parents' wishes in a court of law.
One essential point to note is that education is not just an action that a child receives. The school itself is a place where the child can act in freedom away from the influence of the parent. May I finish my thought?
Please.
And in cases such as Tinker v. Des Moines, 1968, the court has established that minors do have rights within the school setting.
Thank you.
Great job. Let's recognize the students for their outstanding hard work and participation.
Great job. Would one of my colleagues like to begin feedback?
Sure. I think that the opening was tremendous. It was well structured, pretty deep, darn rich, and a lot of good stuff. The idea that Smith is hanging by a thread is certainly a legit point, and one that it was worth talking about. We then, in the Q&A, I think y'all handled yourselves relatively well. I do think we got a little turned around when talking about Smith and Tandon, but that's because in part the cases get a little turned around. I thought the points about the right to education and fiscal federalism were really strong. No Child Left Behind, and the notion that the federal government's already involved in education, I think is important stuff. So I was happy with the conversation. I think we could have gone on for a lot longer. Don't know whether you all would have wanted to, but I think we could have gone on for a lot longer. And the conversation was great. So good job. Good job.
Thank you.
Yeah, I would agree. I appreciated the kind of the framing at the outset of whether it's a positive right. That means, it's something that the parents can choose to reject. I thought that was an interesting way to frame the decision. And then the disagreement on the other side of how it puts the parent over the child's interest, I thought was good. I also really appreciated the discussion of the balancing and going through the different tests and Smith and how it's it's hanging by a thread, but the Supreme Court won't admit that, right? They keep saying everything they're doing is consistent with Smith, and it's difficult to reconcile, at least for me. And I think you guys you appreciate that, which is a sophisticated understanding, and the notion of the weaponization of the free exercise clause as a concern, kind of as your closing thought, I thought was very effective. The other things I would note, so our discussion of Tannen was fun. Full disclosure, I've worked on that case at the Attorney General's office, and I think it's a tough decision to understand, at least from the state's perspective, because there you did have, what they're asking us to do in Smith, passing a generally applicable law. We had a law, it was generally applicable, no gatherings with more than 3 households, period. And yet that still didn't suffice. But I thought, Rohan, you did a good job of articulating why they held that and why they came to that determination. And so I thought that was effective. The only other thing I mentioned, I wanted to just echo Judge Chambers' point about, I thought the fiscal federalism point, again, was a very strong point, noting that that even if you were to suddenly recognize a federal fundamental right, it's not going to change all that much. They're already influencing the states through the pocketbooks. I thought that was a good point. Well done.
I agree with my colleagues. I liked the very opening where you had the 2-2 dichotomy on the validity of the Yoder decision. And I thought that was reflected later on, as Judge Glickman said, that interesting difference of opinion between Rohan and Mary on a subsequent decision. I thought you played off each other very well, and that it came across as very effective. I, like Judge Chambers, just thought it was a rich conversation that could have gone on a lot longer, and just want to wish you all the best and thank you sincerely for your hard study of the Constitution, and I hope you'll continue it. Thank you.
Thank you so much.
Yeah, congratulations. I'm sorry it's all over for you guys. That's the worst part about being in the finals. You don't get to do it again, but best of luck.
Congratulations, and yeah, best of luck, when the results are announced. And yes, yeah, fantastic job.